Last night, or rather early this morning after midnight, I made a voice file. It's about 20 minutes long concerning what would have gone into an argument or what is going into an argument for a request for issuance of warrants, as well as other action to be taken, including potentially processes by which it can be effectuated, to intercede at what I understand to be one of the primary entry points of human trafficking connected to acts of money laundering that have disabused access to people for access smuggling, specifically using misappropriation of means available through the Health and Human Services system, as well as other sorts of social service providers that presumably assist people that have experienced homelessness or domestic violence. I understand that the intercession through the resource networks in order to accumulate or to acquire those resources that people have a need for when they have come into an emergency or some sort of traumatic or crisis situation are a primary picking point for human smugglers, especially human smugglers that are engaged in acts of public corruption and are disabusing government modalities in order to engage in acts of organized crime. And that specifically for the last 10 years, there has been an intentional effort to destabilize the federal government and allow for elements of these organized crime syndicates to become more entrenched. This is not a recent phenomenon. This is something that has been happening with greater and greater accumulation since before the S&L crisis, but because of the manner in which the S&L crisis was allowed to be handled and things that did not happen, primarily the allowing for the offloading of responsibility for acts of domestic money laundering to be focused on foreign origin points or foreign points of distribution as opposed to the locus of trafficking and crime domestically, that it has been allowed to create this unsustainable saturation of public services and public resources that has enabled organized crime to thrive and to actually occupy the government and create a modality through which organized crime can proliferate to the expense of actually engaging in effective administration of government. And so we are talking about gangs, but we're talking about very high profile gangs that have some serious backing, presumably educational backing and professional backing and legal backing and the cover of sovereign immunity by virtue of having gotten into and infiltrated the government and established themselves. Now, the specific role of the State Department, specifically through its intercession as the screen on CIA activities, is actually on one level not relevant. The attempt to try to classify it or characterize it as a covert operation that somehow is justified because it provides some sort of national security leverage, especially when it does specific kinds of recruitment of people who were born in other countries and or attempts to prioritize advantages accorded to people in other countries is not even the major primary point of relevance. It is, however, potentially evidentiary of the intent behind the modus operandi of the organized crime syndicate. And the fact that it is allowed to be misrepresented as something that would be able to be covered up by the State Department masks the thoroughness of the infiltration of the government by these organized crime syndicates, which is why a past history involved in so-called intelligence, while there is also a cumulative record of abuse of public office in other areas, is necessarily the kind of thing that needs to be examined and not allowed to say, well, because it was officially intelligence, we don't have to disclose. That's not actually true. Even under the presidency of Bill Clinton, there was a requirement regarding 25 years after which things that had previously been classified for national security purposes were mandated to be made available to the public. Nobody has the right to co-conspire to implement that with an intentional bad faith effort to defraud the entirety of the government because they knew damn well they put a 25-year term on it, because after 20 years they were going to start sabotaging the government so significantly that by the time the 25-year term came due, well, everything was confidential. And now we have a crisis regarding COVID-19, which justifies extraordinary measures, including, well, I'm sorry, we're just not able to actually activate that law that was put into effect 24 years before we started providing illegal laws saying we don't have to disclose things we're actually constitutionally required to disclose. And it's exactly what's going on right now. I have right here that evidence that I did not get stolen. And among the evidence are a few things. One is an article regarding what it means for the government to be a controlling shareholder. And one of the things this document discusses is right here in the first paragraph. As a result of the 2008 bailout, the U.S. government became the controlling shareholder of some major U.S. corporations: AIG, Citigroup, GM, GMAC, Fannie Mae, and Freddie Mac. Just this past summer, a major 10-year benchmark came due with AIG. I've been tracking it ever since. The implications of that 10-year benchmark and what is going on right now are very, very significant and cannot be ignored, and also cannot be classified for national security purposes. By virtue of inserting themselves as shareholders in the way they did, the federal government became specifically positioned to be mandated to disclose certain matters. It had absolutely no authority to then try to say it could classify as being connected to national security. That includes the means by which people's electronic accounts were allowed to either be collateralized or commercialized, as opposed to being able to fulfill necessary processes connected to civil participation or ordinary political process, or in the case of people that were public employees, actual mandated reporting and compliance with their jobs. They didn't have a right to do that. It's unconstitutional and illegal. And additionally, if in fact they have, which is one of the allegations, disabused the nonprofit sector, including but not exclusive to engaging in faith-based initiatives as part of provision of social services, to use human beings' resource needs up to and including their intercession with the Social Security and or Medicare programs, as well as other kinds of health insurance and or their intercession with the criminal justice system, including in connection with some sort of alternative treatment program for drug abuse or drug and alcohol abuse, to create venture capital opportunities that are actually explicitly in violation of the Constitution, specifically the 4th, 5th, or 6th Amendments of the Constitution, but also the 14th and the 13th Amendments of the Constitution, then we have a need to act right now. We should have already been acting. As a matter of fact, in 2018, I composed a spreadsheet, and the specific intention of this spreadsheet was to see a basic systematology whereby I understood people who had been entered into the Health and Human Services system and put into the database could have their human capital classified in a certain manner based upon the way they enter their information on the applications for the admission, that can then be compiled within databases to create regimes and particular kinds of transactional moments based upon combinations of human capital that were available in certain time frames and in connection with certain groupings of people. These are behind the charges that were part of my writ quo warranto to the state of Texas through the Supreme Court of Texas in June of 2018. June of 2018 was before the announcements of the major aggregations on the U.S.-Mexico border, excuse me, that were part of what were alleged to be surges, or specifically called and organized caravans of refugees from Honduras and Guatemala up through Mexico to the US-Mexico border. But it was at a time when there had already been contestation about the way that children who had been removed from their parents within the domestic United States were being addressed on a federal level, both by the president but also by Congress, as well as people that were working with them directly. As a matter of fact, there was an event where the First Lady came on site to camps where children were being housed and staying. And this had caused some controversy in May of 2018. Perhaps you remember. This was also around the time where they were discussing how minors were being put in military or decommissioned military facilities, specifically in Florida, and this also caused some controversy. But both of those moments were before specifically coordinated, organized caravans of refugees were announced for departure in Honduras, exactly as there was an issuance pending for a major municipal bond that was connected to an organization that within the past 10 years had been accused of and convicted of engaging in fraud when it came to municipal pension funds for the municipality involved. And so when these caravans got called around that bond issue in connection with the events that were ongoing with it, it revealed a pattern that has persisted since. And since that time, this specific organization and the matrices connected to this organization, as well as the banking institutions and the brokerages, have been responsible for hundreds of millions of dollars of bond obligation issued at exactly the same time public announcements are made in the media. And there are exhibitions of people amassing in a caravan to depart Honduras specifically to aggregate on the US-Mexico border. Somebody is abusing systematologies connected to public employees' pension funds to specifically traffic people out of Honduras and to the US-Mexico border. And my understanding is it is connected to a competitive bidding scheme on how many of those people they can get into the United States and where those people end up. Be honest. That's what it's about. And if they end up in the US, who are going to be the primary people to be advantaged? I contend it is people that are going to be connected to the advantages that one is availed of when they serve as a member of a board of directors at a nonprofit organization that is in network to be the recipients of resources that are distributed in order to assist these people. And the incentive is that they get to use these people and these people's access to resources as a sort of scheme engaged around derivative processes associated with the corporations they're in network with, and or the parent company or investment fund that they are involved with as a subsidiary with others, or more specifically, and in some ways diabolically, as a countervailing force to specifically and strategically coding certain people as a form of central counterparty in order to make them into an asset for a competitor that can then be sabotaged, with an understanding that after they have made these certain people into assets of competitors, that they can sabotage and interfere with and or try to extort people into engaging in illegal activities in their resource acquisition so that they can leverage the means by which they have tried to sabotage their competitors as a means by which to acquire advantage for themselves or those in their network. I've been tracking this literally for years, and I personally have been subjected to it for 4 years in 2 states and several cities, usually through the same sort of network, wherein you are referred through a public agency to a presumable private provider of resources. But that provider of resources is in network with people that hook you up to get public resources, including resources through HHS and HUD. And your acquisition of resources through those government-funded programs then ends up giving information and transactional moments and events connected to you, meeting benchmarks associated with the public resources, the availability of the private resource that is providing you with the complementary benefits So they use your public access resource acquisition as part of their hedging strategy. And in the course of that, assign you as an asset, either for someone that is a colleague or is a competitor. And depending on your disposition and your demographic profile, they may or may not intentionally sabotage you and or use you and your resource acquisition as a means by which to try to offload or offset liabilities that have been acquired and accrued as part of their system. More than that, as one can see, just by virtue of the nonprofit organizations I have had to go to try to get my immediate needs met in the state of Texas. Members of these boards of directors are involved with companies that are constantly engaged with bidding when it comes to procurement of contracts with the federal government, including through the Department of Defense. And now with COVID 19, there has already been set in motion a series of processes whereby they can obscure the previously required reporting on their relationships with bidding for contracts, both with states but also with the federal government, while they are also able to avail themselves of whatever's going on with the COVID 19 relief that was already set up in their pipeline based upon their previous experience being involved with resource acquisition and venture capital associated with their involvement with the Health and Human Services and or HUD via relationship to their service as a member of the board of directors of these nonprofit organizations, i.e., in another level, what they have said when it comes specifically to people involved in some sort of assistance work internationally, that it's called money laundering. And it's called using charities to launder money in order to finance acts of terrorism, including acts of domestic terrorism. In just this year, there have been 2 major acts of terrorism that have been pre-orchestrated and specifically, literally, precisely executed in connection with a specific pattern that I have been attempting to have forestalled, directly connected to the matrix of events that are associated with the compositions available based on the boards of directors of 2 major organizations primarily headquartered and based out of Texas. So, what we need is an execution of a warrant to allow a process whereby the boards of directors of these specific organizations, specifically the Baker Ripley organization and the Salvation Army, are taken out of the context where they provide a fiduciary role, and the advisory committees of those organizations are likewise enjoined from or put under an injunction against any sort of benefit, while within the next 72 hours, the records associated with their service as board members and or advisory committee members are procured as part of evidence with a specific focus on things that would be evidence of the relationships they have to identifying or participating in processes of identification of individuals in those networks as assets, either of them and their subsidiary interest or as competitors, and then cross-referencing that with the last 10 years of events connected to the companies who have provided and who credit their employees, including their executive employees, for their service on these nonprofit boards with any efforts they have used or made to engage those companies or those that are in interest with those companies in processes of competitive bidding that constitutes illegal procurement by the definition of the law, as well as involvement in acts of human trafficking or smuggling of other materials, including ones that legally qualify under the existing laws connecting money laundering or countering money laundering to efforts to combat terrorism. Now, if one is concerned about the specific implications about using this in illegal acquisition or distribution of dangerous drugs, or unfortunately, especially with what's going on right now, the acquisition and distribution of biological weapons, then rest assured that the legal foundations for such considerations are covered under a conceptualization of pursuing this as if it is an investigation of money laundering connected to acts of terrorism. But it's also understood that the operationalization has to take into consideration the cover of the execution for this kind of crime based upon the abuses of the government office, starting with executive mandates by the President of the United States that have allowed for its operationalization, and a refusal of the other two branches of government to check against its abuse.